Senator from Texas, time has expired. Senator from Tennessee.
Thank you, Mr. Chairman. I appreciate that. And Justice Sanchez, thank you for coming before us today. A timely question for you. Do you believe that the right to keep and bear and own arms is a civil right?
Senator, under Heller, it is the right to keep and bear arms is a constitutional right that all citizens possess.
Do you support the Second Amendment?
Senator, I support all amendments, all express rights that are in the Bill of Rights and rights that are recognized by the United States Supreme Court.
Okay. Let's talk about this, continuing with California Proposition 57. There are a lot of Californians that are moving to Tennessee. One of the reasons that they cite for leaving the state are very high taxes, and another is a whole lot of crime. And the way crime on the streets has changed so many of the communities. Now, I know you didn't want to answer Senator Cruz's question, but let me come at it a different way. Because when you look at the work that you have done on this, talk to me about what guides your judicial philosophy on sentencing.
Okay, thank you, Senator.
Yeah.
My policymaking past is just that. I served as a staff member for Governor Brown, working to effectuate his policy goals.
Now, what
and vision.
principles guide you?
And
what is the purpose of punishment? Because, see, you've just talked about you knew there were people that were going to be released. You were hopeful people were going to go through rehab, but then you kind of contradict yourself. So why don't we do this? Why don't you just submit for the record what your philosophy is on sentencing and what you think is the purpose of incarceration, the purpose of punishment? Because I don't know of anybody. I talk to people that have moved out of California every single day, and they are so frustrated with the way the state is being run. And so they're choosing to leave. Let me move on to People versus Silas and ask you about that. Now, I understand that involved a preemptory strike on a prospective black juror, correct?
Yes.
Okay. And as I understand it, the prosecution exercised a preemptory strike against a black juror who expressed support for Black Lives Matter, citing the juror's hostility when asked about BLM. And you issued a decision that suggested that the prosecutor's preemptory strike was actually motivated by discriminatory intent based on the juror's race. And I would like to know more about your thinking in that case, because it seems to me, as I looked at it, that you're conflating support for BLM, which says that they are a trained Marxist leaders in this group, that you're equating that with race. So why don't you talk just a touch about that? We've got a limited time here.
Thank you, Senator. As you mentioned, the claim was brought under Batson versus Kentucky, in which the Supreme Court held that use of a peremptory challenge by the prosecution to excuse a juror on the basis of race violates the Equal Protection Clause. On review of that appeal, we looked at the three-part analysis of whether the plaintiff had made a prima facie case of discriminatory intent. And in that case, the questioning was conceded by the Attorney General to have been inappropriate with regard to the Black Lives Matter movement. But there were other indicia in the record as well of evidence of a discriminatory motive. For example, the prosecutor's explanation for excusing the juror involved that the potential juror was late, when in fact it was a different African-American juror that had been late. And there were other aspects of the record that supported an indicia that the prosecutor was substantially motivated, at least in part, by a discriminatory purpose.
Okay.
It wasn't only Black Lives Matter, but that played a big role in the case.
Okay, thank you for that. Demand justice is a far-left group that is supporting your nomination, and you've expressed preference for, and I'm quoting, diversity of experience and perspective in the courts. And in light of this, I would like for you to define what you see as being appropriate action on the bench and judicial activism.
Thank you, Senator. Judicial activism to me means when a judge allows their personal viewpoints or policy perspectives to pervade their decision-making. It is not an appropriate thing for any judge to do. A judge should consider the court, the party's arguments, the lower court's decision, and the governing law.
But Demand Justice likes activist judges, and they're supporting you. So do you agree with their philosophies?
Senator, I'm not familiar with Demand Justice's philosophies. I can only speak to how I approach each individual case that comes before me.
Okay. All right. Thank you, Mr. Chairman.
Thank you. Senator Tillis, do you have any questions of this witness? Okay. Judge Sanchez, thanks for